Hello realtors, my name is Prasad Amonkar, real estate consultant and real estate coach, and today I am going to continue with our last left topic, which was agreement of leave and license. Last time in my last video I discussed about why you should get into rental business, why it is a recurring source of income, why it is a source of income for you even if you are a beginner or even if you are an expertise. And I also discussed about how you must draft a leave and license agreement, though it is done by a lawyer, but you must know the checklist, you must know all the details required to be furnished to the lawyer. Or sometimes there is a standard draft which you have been doing for years and it becomes so easy for you to draft it again. And today I'm going to continue, and let's straight away go to the topic. So in the details, as I mentioned earlier, you must also mention the size of the property. If you have the floor plan of the property, then please attach it with the leave and license agreement. Suppose in case you are doing a part of the property, if you are renting a part of the property, then it is advisable to put a plan, the floor plan, which shows the proper demarcation of the property which is given on lease. But if you are doing the entire property, if the entire apartment or the whole house or the villa or the premises, the entire property is given on rent, then this may not be required. But as we do it in outright, this is also recommended. In case of amenities, there could be internal and external amenities. Now in case of internal amenities within the premises, the client is giving you the list of these amenities is also mentioned in the leave and license agreement. Sometimes some clients or some properties or some complexes do not allow the use of the amenities for the tenant. So, like sometimes the membership is taken by the owner, but it is not transferable. So if there is a pool or clubhouse or some gym, something like that, it cannot be used by the tenant. So you need to clarify that from the beginning, because once the property is rented out and the owner, the tenant is not in a position to use the clubhouse, then it will be a problem for you, because it will be you will be in a situation in the middle of the agreement itself, in the middle of the period of the agreement, there will be a lot of goof up. So try and understand this. It's also important for you. So we mentioned the rent which is agreed. Now the rent is basically agreed upon. It's mutual consent, the tenant, the licensor, the licensee, and it all depends on the market price also. Like suppose you are in one particular area wherein a modern complex is fetching about 35,000 or 45,000 rent. So similarly the rent is arrived at. Suppose you are in a situation like COVID situation, there is some discounting also done. Suppose the market price is 35,000, the discounting may happen and you may get it for 30 or 28,000 or 25,000. It all depends on the situation of the tenant and also on the situation of the licensor. Sometimes the property remains vacant, so the owner becomes little, he gets that anxiety. He feels that I must give the property on rent at whatever price I'm getting now. But most of the times the licensor is very adamant and he doesn't want to negotiate on the rental so much. You know why? Because he thinks that if the client is not paying him a proper rent, he may not also keep the property in that proper condition. So the rent is not so much negotiated, but if the client is good and both parties agree, there could be around 10 to 20% of negotiation on the entire rent. So you need to mention the proper rent. Now this rent also includes the maintenance. In some cases it may not include maintenance, because in some complexes the maintenance amount is very, very high, so it need to be paid by the tenant, or maybe the maintenance amount is connected to the membership. So in that case the tenant, the licensee, may pay the maintenance fees. But mostly see that you agree to the rent including maintenance, so that there is again no dispute tomorrow once you have agreed upon the rest of the terms and conditions. Security deposit is taken as 2 months or 3 months. See, right now in some states it is 2 months, in some state it is 3 months. So it all depends on what is the standard in that particular location. Security deposit is taken for a reason. What's the reason? Basically, suppose if the tenant is not paying the rent, so it gets adjusted in the security deposit. Suppose there is a major damage in the property while the property was occupied by the tenant, again the damage good to loss is taken care from the security deposit. Sometimes the outstandings are not paid, maybe the maintenance fees or the electricity, water bill, whatever the outstanding. Sometimes the Wi-Fi connection charges, the telephone connection charges, which the tenant has been using at his own cost is not paid. So the same thing has to be borne by the licensor now. So that's get adjusted into the security deposit, and security deposit is not adjusted against the rent. Suppose if you are, you have this 11-month contract and you are in the 9th month, and you know that now you are going to leave the premises after 11 months. So you give him a notice of 2 months or 1 month, depending upon whatever terms and conditions you have arrived at. Now you cannot tell the licensor that okay, you adjust my next 2 months into from the security deposit. It's not done that way. Security deposit is kept to be refunded back to you after the completion of the term. So here you cannot adjust it against the rental which you are paying regularly. As a licensee, you must pay the rent on a regular basis. Sometimes the tenant get he develops a fear that after 11 months he may not get my security deposit which I have paid, so he tries to adjust the remaining 1 or 2 months from the security deposit. The rent gets adjusted, and most of the times it happens that way only. What I have seen, people do not pay at the end of the term, and the security deposit gets adjusted from the rent itself. Advance rental is taken initially. Now there are 2-3 things. One is the rent which is arrived at. So when you are drafting the agreement, you must draft the agreement with 1 month rental advance. That means, for example, if you are in January 2022, so you are going to occupy the premises from 1st of Jan, then you need to pay the rent of the January in advance, like 1st or 5th maximum, or when you are drafting the agreement. So the owner is getting how much? The owner is getting the 1st month rental advance, and if there is a 3 months deposit, then 3 months deposit is transferred. So there are 2 transactions over here. Now the rental advance, here it is, the rental advance and the security deposit. So that means 3 plus 1, total 4 months. Suppose if the rent is 30,000 now, that means the client has to get about 1.2 lakhs. That is 30,000 into 4 times is what he gets. In some cases, the security deposit is 2 months. So in that case, that means it will be 2 plus 1. Always see that the rent is paid in advance. It cannot be paid at the end of the month of occupying the premises. Structural changes. Now, when you take a property on lease, rent, it's not owned by you, so you cannot, as a licensee, you cannot make changes inside the property unless you take proper permission. Now here the minor changes are allowed, like you want to put some frames, or you want to do some maybe some wallpaper, or give an aesthetic look to the property. You need to take permission from the owner, and that's how you can do the minor changes if it is agreed and if it is mentioned in the agreement of leave and license. External changes, not at all. It is not, you cannot do any external changes of the property. Anyways, if it is an apartment, external changes cannot be done because it's the whole building. So you cannot make any changes. But if it is a villa and you want to do some external changes, not possible at all, unless there was some damage earlier and now the external changes is recommended by the owner and the licensee is ready to bear that cost. Maybe a pool in a villa. If the licensee wants a pool in the villa and is ready to spend on that, of course it is possible. I have done that also. Painting work. See, when you take the property, the licensor is supposed to give a proper whitewash in the apartment and give to the tenant, so that when he leaves the premises after 3 years and all, then the licensee has to repaint the property and give it back. Now again, it all depends what is mentioned in the leave and license agreement. If the painting is not mentioned, then he did not do the painting while he is leaving. But mostly the painting is done at the beginning, and if you are staying for a long term like 3 years and all, when you vacate the premises, it has to be repainted, the whitewash, and then it has to be handed over in a clean, neat condition to the licensor. This is what happens when it comes to the structural changes. You cannot simply do structural changes. You can't do anything like the way you want, because it's not your house. You have actually just taken it on a temporary basis. That's it. Okay, then the next point would be, what are the duties of licensee and the licensor? Now, in case of a licensee, the more of the duties are from the licensee. because again, as I said, you are using it on a temporary basis. The first thing is that you need to take care of the premises. Now there is no rocket science that how do I take care of the house. See, there is a kitchen, there is a living room, there are sofas, then there are beds. You need to take care of that. You need to also sometimes do the pest control, because of course it's a house, you cook over there and the kitchen may get pest. You need to do the pest control, you need to maintain the house, you need to see that your kids are not drawing on the walls of somebody else's house, and if it is done, then you need to make a good to loss to the client. So take care of the house as if you are going to take care of your own house. See, when you stay in your own house, if there is some damages, it's your house, it is okay. But if it's somebody else's house, even a small thing gets noticed, and that's where the relationship spoils. So try to see that the house is taken care properly. You need to stay in peace and harmony within the property, within the house. Like, you can't be shouting, or you can't be like fighting within the family and outside the family. Like, you go out and you're fighting with the neighbors. Because see, you just entered the house and you have been not staying there. There's a proper complex and people are been living there for 5 years or 10 years. Suddenly you enter from outside and go to see that you are fighting with the neighbors. You are getting into a situation where you are not obeying to the bylaws of that particular society, and that's where the problem happens. You may get into problems because generally within the complex outside, people don't like someone coming on the rent, and if they are misbehaving, if they are not keeping that peace and harmony. Regular rent payment is very, very important. That's the essence of the leave and license agreement. If you are not paying a proper rent on time regularly, there is a chances that your rent agreement may get terminated, and you may have to vacate the premises early and not after 11 months. So pay rent on time, in fact before time. Suppose if your rent is like it comes on the 5th or 7th, try to pay it on 2nd or 3rd. That shows your credibility to the owner, to the licensor, and that relation will remain. Okay, there should not be any breach of the leave and license agreement. Whatever is mentioned in the leave and license agreement, whatever the terms and conditions, the clauses, you as a licensee cannot breach any of those. Suppose if the complex does not allow pets, and you have written over there, you have signed on that agreement, and then suddenly you get a pet over there, it's not allowed. So don't do that. Something which is already agreed on the leave and license agreement, it's a legal document, so you can't breach that. Once you breach the contract, you may have to vacate the premises. That's how the things happen. Now, peace and harmony I have already written. I think I have written second time because maybe I give that more important. So that's what happened. Minor maintenance has to be taken care by the licensee. Suppose there's a flush, or there is some electrical points, there is some repairs has to be done, like 200 rupees, 1000 rupees, 2000 rupees. This comes in the minor repairs. Some agreements people write what is the minor repairs. If the minor repair is mentioned, like up to 2000 rupees has to be borne by the licensee, and beyond 2000 rupees, unless the damage is caused by the licensee, then it has to be paid by the licensor. For example, you need to change the fan, it has to be done by the licensor. If you think there is a problem with the AC and it's a major problem, it has to be done by the licensor. If you think there is a security lock which has got spoiled, now that's something which is not because of you, so that has to be changed by the licensor. But if there is a flush problem which costs you about 200 rupees, there's a one switch which has to be repaired or replaced, has to be done by the licensee. And whatever normal pest control has to be done by the licensee. So all the minor maintenance has to be taken care by the licensee, or the major cost has to be taken care by the licensor. And this major maintenance, again, it depends on who has done that thing. Like for example, if you, while using a particular appliance, if you have damaged that, like maybe fridge or washing machine or the AC, if it is not serviced on a regular basis, obviously it's going to give a big bill at the end of 6 months or 8 months. So don't do that. Try to keep things regularly maintained, so then it will not lead to a major. Let's come to the licensor part of duty. So as a licensor, he also he has to also see that the licensee gets a comfortable stay in the property, because he's getting money, right? So he's getting a lot of money, I mean really a lot of money from the licensee. So he need to give a proper amenities to the licensee. He need to provide proper water connection, electricity. There should not be too much of fluctuation because of the licensor. If the bills are not paid on time or whatever reason, if the electrical connection is not proper and it is damaged, then it will lead to fluctuation, and that's what bring uncomfort to the licensee is to be taken care. Major maintenance, I just discussed with you what is major maintenance, has to be done by the licensor. And of course, you see, there's no rocket science, there's no standard operating procedure that what is major and what is minor. It all depends on the situation. So here, as a good licensee, you need to understand that you need to keep the house proper, and sometimes maybe you have to incur whatever cost gets incurred in major expenses. Also, you may have to shell out some part of it because you have been staying there. So it's not fixed that what's the amount of minor and what's the amount of major maintenance. Now coming to this portion of notice period, in most of the leave and license agreement, the notice period is 1 month, 1 month or maybe 2 months. So in some cases, when they do a 2 months notice period, it becomes good for the licensee. And if it is, and in fact it is both ways. Suppose if the licensor has to give a notice to the licensee, 2 months is a big time for him to go and look out for a premises, and it's vice versa. But I would recommend 1 month because mostly it's easy to find a property on rent in 1 month. Within 15 days you'll get the property, and then because nobody will wait for you for 2 months. Suppose you got the notice of 2 months and now you go out as a licensee to look for the premises. The other client, the other owners will not give you premises, will not wait for 2 months for you. They'll say you come after 1 month, and if it is available we'll give you, otherwise it's gone. So that's how. So 1 month notice period is recommended for licensee. It's good for him. For the licensor, what they do over here, I'll tell you. Okay, they do something called as lock-in period. In this lock-in period, in that agreement of leave and license, they put a 6 months clause that you can't leave in 6 months. Even if you live in 6 months, your security deposit gets forfeited. And after 6 months, there's a notice period of again 1 month or 2 months. So generally, why it is done, because in some places where there is a lot of tourists which comes, they take the premises for 3 months and they leave. And they stay, instead of staying in a hotel, they stay in a nice house with a nominal rental what they pay. Suppose if they pay 30,000, the same kind of accommodation they'll get for 60,000 or 70,000 in a hotel. So they stay on a temporary basis, and they it's not good for the licensor. So what we do generally, we put in a lock-in period of 6 months so that the client will not leave within 6 months, or even if he leaves, the security deposit gets forfeited. Because see what happens, licensor is paying a brokerage also. So when he's paying a brokerage, he gets a security deposit of 3 months. 1 month is gone in brokerage, only 2 months is left. Now if the tenant leaves in 6 months and these 2 months get adjusted, what have we done? Because the broker is getting the brokerage for the entire 11 months and the client has left in 3 months time. So the broker got more money. So that's why the licensee sees that he is covered as far as the brokerage is also concerned. That's how it goes. Termination clause for the licensee, it's basically the end of the term. 11 months got over, now tata bye bye. But it can be early termination from the licensee side. Suppose if he's a government employee or he's been transferred over here as a bank employee, he would like to take a early termination, and that's how the termination. And as I said earlier, if there's a lock-in period of 6 months, then he has to fulfill that criteria. But if you have crossed 1 year, 11 months, and then again you are doing a renewal, the lock-in period clause will not come again. This lock-in period clause will not come again because you have already crossed 11 months. And now only one clause will come, that is the notice period. Either the 1 month or the 2 month thing. Now the termination clause for the licensee, again end of the term after 11 months, he can just say that okay, now it's tada bye bye. Okay, or it could be a early termination. It's called early determination, wherein if there is a breach of the clauses mentioned in the agreement, then there could be the early termination. Or if he finds that the tenant is not paying regularly, or he is not maintaining the peace and harmony in the property and outside the property, he may ask for the early termination. And that's little scary for the tenant, because suddenly they will be asked, if there's a breach of any clauses, he can be asked to leave immediately. Suppose if he is caught in some criminal activity, he would be asked to vacate immediately without any notice, not even 1 day or 15 days, nothing. Immediately he has to vacate. Now how do I get my refund of security deposit? You can see over here, money against house. So you hand over me the property in a nice condition, proper condition as I gave you earlier. I will give you money back as a licensor. So when you vacate the premises, you have to vacate the premises as per the agreement. The last date is done. Suppose you overstay, there will be a payment penalty as well. They also check the damages, as I said earlier. The keys has to be handed over and all the outstanding dues has to be paid. Water, electricity, maintenance if applicable has to be paid, and that's how you will get your refund from the licensor. Give his house, he will give your money. Of course, there are some conflicts, some disputes always happen when it comes to the refund of the renew of the security deposit. Renewal comes after 11 months, and the increment of 10% or 5% or 7.5%, it all depends on, and there could be no renewal also. Now when it comes to leave and license agreement, they at the end of the agreement they write, like 5% or 10% of increment. But after 1 year, not necessary that you have to follow this 5 or 10% because it's a fresh agreement. Though it's a renewal, but again it's a fresh agreement. So in that case, you may agree to continue with the same rent or 5 or 10% increment. It all depends on your repo, and it all depends on the situation of the market. If the market is not that great that the licensor can afford to let go the tenant and get a new one, because when he has to get a new tenant, he has to pay brokerage again, and also there will be layoff. There could be like 1 or 2 months he may have to search for another client. So rather he compromises with the rent and he gives the property to the same client at the same rent most of the times. Okay, so in case of dispute, it can go to the arbitration or court, but just try to avoid all these matters because over here the money involved is a smaller amount. In the rent and the security deposit is a smaller amount. So try to get this leave and license agreement drafted in such a way that it is more of fair for both the parties, and there is no dispute and everything gets settled. And if you have done a proper due diligence of the clients, you will end up having a good termination. Penalty depends on overstay and damages. Now overstay is basically, suppose if you had to vacate the premises on a particular time, you have to give the premises. If you overstay for even 1 day, in the clause they mention like 2,000 rupees or 3,000 per day cost. So that you have to pay. Suppose if you are overstaying, it will be applicable to you. 11 months, the registration of the document, how the document will become legal as such. Once you have done 11 months notary, then it becomes a legal document. If it crosses 11 months, like 12 months or 13 months or 2 years or 3 years or 5 years, you need to register that document at the sub-registrar, and there is a proper stamp duty need to be paid, and there is a proper uploading of the document has to be done. Both the parties has to come and sign in front of the sub-registrar. It is exactly similar to the outright sale deeds. That's what happens. Most of the companies prefer doing a registration at the sub-registrar. They don't mind paying a higher stamp duty because it's a company like companies like the banks like RBI or SBI, or any particular or corporates like Bharat Petroleum or HP or any, I'm just saying some names, but I'm saying maybe the corporates or the government authorities, they always do the registration of the document at the sub-registrar. That's very important for them. Okay, that's it for now. It will be continued, and you must be wondering what am I going to continue. After doing 2 videos, I have something more for you to talk about on agreement of sale. If you have liked the content which I give you, please like and comment. If you comment me on certain topics, I can take up those videos as well. Please share my video, because when you share the video, a lot of people will know about the business, and when you give, you always gain. So don't keep this knowledge to yourself. Pass it on to the realtor friends of yours, your groups or your association, and do not forget to subscribe to my channel to get more notifications and more videos, and I'll be happy to help you always. Thank you very much.